Hello, and welcome to Group 8's presentation, titled The Legalities of Terminating Employment. We hope you enjoy our presentation and find the information to be as useful as we have.
You're fired.
That's a phrase we are all familiar with. Employment termination is a complex issue. Being fired is an emotional process for both employee and employer. The employee now has to deal with setbacks to their finances, reputation, and self-esteem. Walsh states, for employers, terminations are stressful, occasionally dangerous, and apt to prompt legal challenges. An employer's lack of knowledge on the laws regarding employee termination may leave them exposed to the risk of litigation from former employees. This presentation will provide a more in-depth look at terminating employment in the workforce, specifically focusing on the employment laws applicable to termination, how employers' ignorance of the law can lead to the mishandling of termination, identifying the legal risks associated with terminating employment, and providing recommendations to employers on how best to mitigate these risks. The topics covered in this presentation will be as follows: the legal standards governing termination, at-will employment with exceptions, constructive discharge, contract-related claims, public policy exception to employment at will, civic duty laws, off-duty conduct laws, discriminatory termination, potential legal risks of termination, and proactive methods to avoid legal risks. Termination of employment occurs for many reasons, and the differentiation of these instances vary. An example of this is understanding the difference between a group of employees being terminated because of downsizing and a single employee being terminated because of factors unique to the individual. Another example is the understanding of the laws differentiating between public or private sector employees as well as union members. There are some segments in which employees may have more protection from wrongful termination. Some of these segments include unionized employees, residents of Montana, those working for the government, contractually bound employees, and those reinstated from military service. In some instances, employers are required to meet a standard of just cause, due process, and typically provide a history of progressive discipline in order to terminate the employment of these individuals. About 20% of the members of the U.S. workforce are protected by the just cause, due process standard. As employers, the first step to mitigating the risk of wrongful discharge litigation is to have a full comprehension of the different laws for the public and private sector employees, as well as union and non-union employees. Many employees believe they cannot be fired without just cause, but the reality is the majority of non-union employees working in the private sector can be fired with or without cause, as long as it is not for a reason that would be considered illegal. This is defined as employment at will with exceptions. At-will employment with exceptions is the middle ground between pure employment at will, which gives employers a significant advantage over employees in regards to termination, and the just cause due process standard, which affords many more protections to employees and inhibits the ease with which employers can terminate employment relationships. Under pure employment at will, Walsh states, an employee without a contract of employment for a specified term can be terminated at any time for good reason, bad reason, or no reason. With the realization of how central employment was to an individual's livelihood, compounded by the lack of protection from wrongful termination, came the addition of common law and legal exceptions to employment at will. By the 1980s, these exceptions were formalized, and pure employment at will had truly evolved into employment at will with exceptions. Employment at will has been continually modified to include wrongful termination claims. According to Walsh, the exceptions to employment at will for most private sector non-union employees boils down to the following impermissible grounds for termination: terminations that would breach an implied contract or other contract-related obligation, terminations in retaliation for employee actions that thwart public policy, terminations that interfere with the exercise of statutory rights, and terminations that are discriminatory. Under employment at will with exceptions, employment is still fundamentally at will and termination is legal, unless employees can prove that the termination was derived from an illegal cause. Employers seeking to protect themselves from legal ramifications must understand the legal protections against wrongful discharge and ensure that they are in compliance with the law. Otherwise, they run the risk of being sued for both compensatory and punitive damage by employees utilizing these legal protections. Laws vary from state to state. Alabama, Georgia, Florida, Louisiana, Maine, Nebraska, New York, and Rhode Island are the only states at-will employees are not protected. There is a difference between an employee voluntarily quitting and having their employment terminated. Constructive discharge is just that, the resignation of an employee when presented with the option of being fired or resigning. Employees who choose to quit waive their right to sue their employers for wrongful termination. An exception to this rule is when employers create insufferable working conditions as a way to force their employees to quit. In doing so, employers are guilty of engaging in constructive discharge. According to Walsh, if under the circumstances a reasonable person would have felt compelled to quit, courts construe the resignation as a termination, and a claim from wrongful termination can still be brought. In order to prove constructive discharge, employees must show that they were subjected to illegal working conditions or treatment at work. They complained to the appropriate supervisor, boss, or human resources department, but the mistreatment continued. The mistreatment was so intolerable that any reasonable employee would quit rather than continue to work in such an environment. Discrimination, retaliation, harassment, and breach of contract are often highlighted in tandem with constructive discharge in order to make the basis of a wrongful termination claim. Employers offering their employees the ultimatum of resigning or being terminated immediately run the risk of being considered guilty of constructive discharge, depending on factors such as how long the employee had to make the choice, if they fully understood the ramifications of their choices. Other options might have been given to the employee along with resigning, and if the employee had a say in the date of their resignation. Employers that humiliate and harass employees in a calculated manner, demote them, cut their salaries, and subject them to degrading work, ultimately culminating in the employee quitting, could be considered by the courts to be engaging in constructive discharge, leaving the employer vulnerable to litigation. Because of the nature of at-will employment, employees making legal claims of wrongful termination due to constructive discharge must do more than prove that they were compelled to quit. Employees seeking this claim prove that their employer's reason for forcing them out was illegal. Giaquinto v. the Danbury Board of Education is a case effectively highlighting the challenges employees face in proving constructive discharge. Giaquinto was a 64-year-old who worked for 35 years as an assistant principal, who claimed he felt pressure to resign after a superintendent made several statements to school administrators, such as, "You older guys better get with the program or you can leave," and told Giaquinto that he was insubordinate. Giaquinto felt he was a victim of ageism, a form of discrimination. However, the court granted the employer's motion to dismiss in this case because Giaquinto was unable to establish a constructive discharge, stating, although the statement allegedly made by the superintendent to the defendant's older administrators smacks of an age-oriented attitude, such an isolated statement is insufficient to demonstrate working conditions so unpleasant or difficult that a reasonable person would have felt compelled to resign. In another case, Miller v. Praxair, the outcome was similar in the court finding that the plaintiff failed to prove the working conditions were bad enough to compel a reasonable person to resign. Employees that are employed at will do not have contracts of employment. However, the right of employers to terminate at will can be limited by the implied contract exception when they make promises of job security to their employees. According to Walsh, even in the absence of an express contract of employment, written or oral statements by employers, and their entire course of conduct in dealing with employees can give rise to enforceable contractual rights to something other than employment at will. According to West's Encyclopedia of American Law, some courts have interpreted such statements as unilateral contracts in which the employer promises not to discharge the employees, except for just cause and in accordance with certain procedures. Courts were more reluctant to find exceptions to employment at will practice in cases that involved an oral promise of long-term employment. Employers can also avoid being liable for enforceable contractual rights by providing written disclaimers to employees. Disclaimers can be used in employment-related documents, such as employee handbooks, as a way to clearly convey to employees that nothing in the document constitutes contractual rights binding on the employee. If used properly, disclaimers can protect employers from wrongful discharge litigations. To do so, employers should display disclaimers prominently and in tandem with definitions of employment at will in any document defining the employment relationship. Also, making sure the content of the disclaimer is communicated clearly to employees and acknowledgement of such material should be obtained in writing. Disclaimers have at times been disregarded by the courts when the document defining the employment relationship and the common practices of the employer are not in clear alignment and create ambiguity in regards to whether an implied contract existed. Covenant of good faith is another form of a wrongful termination claim. According to Walsh, the covenant applies only where there is an express or implied contract and the employer has used the termination to deprive employees of an already earned benefit. The covenant of good faith dealing does not require employers to act in good faith by only terminating employees for just cause. Walsh states that courts recognize claims for promissory estoppel in situations where injustice would otherwise occur because a person has reasonably relied to his detriment on the promises of another. Some examples Walsh uses to determine promissory estoppel might be considered in termination cases would be when an employee relocates for a new assignment or turns down job offers at another organization only to be terminated after doing so. Intentional interference with a contractual relationship is also considered a wrongful termination. The term contractual in this context can be substituted for any type of employment relationship, even employment at will, and holds that intentional interference with a contractual relationship occurs when a deliberate interference causes a third party to breach or not enter into a contract relationship with the employee. Tort damages are available for this claim, but in order to be valid, it must be proven that the interference was both inappropriate and intentional, and a third party must be involved. A good example of intentional interference with a contractual relationship would be an employer intentionally sabotaged an ex-employee, and this prevented the employee from obtaining employment elsewhere or having an offer of employment withdrawn by another party. There are laws in place protecting employees from being terminated in retaliation for an act supporting public policy. According to Walsh, a variety of laws protect employees against termination that, broadly speaking, are in retaliation for actions supporting public policy or that interfere with the employee's rights under the law. Some of these laws include common law claims for wrongful discharge under the public policy exception to employment at will, whistleblower protection statuses, anti-retaliation and non-interference provisions in employment laws and civic duty laws. Walsh states that a number of statutes protect employees against discharge for engaging in specific civic duties. For example, under the Jury Systems Improvements Act, employees are protected from termination if the termination is a result of their service as a juror for the courts. Veterans returning from service in the armed forces are also protected under civic duty laws. Under the Uniformed Services Employment and Reemployment Rights Act, veterans are protected from wrongful termination, and amendments to this act have extended to protecting reinstated veterans from being terminated without cause for a specified period of time that is directly correlated to the time they spent in service. The plaintiff in a 2009 case was a guidance counselor from Washington, D.C., who had been on the job for 20 years and was unable to prove her case that she had been fired for serving as a juror on a 4-month capital murder trial. The federal judge stated, "Sitting as a juror on a lengthy, difficult capital case is one of the most challenging but absolutely critical civic duties of all citizens." This, however, was not enough to prove the plaintiff's case. Although the judge called the principal of the school a very unconvincing witness, she ultimately ruled that because the local school restructuring team branded the job of the plaintiff as an excess, that the counselor couldn't prove her case. In 1987, a Broward jury awarded a Fort Lauderdale woman $2.8 million after she alleged that she was fired from the Pier 66 Hotel and Marina when she served as a juror in a murder trial. Although this verdict was overturned 2 years later, the plaintiff and her employer settled privately for an undisclosed amount. The lesson to employers is that denying employees the right to perform their civic duties or penalizing them for doing so can prove to be a very costly mistake. Employers should have a clear understanding of the off-duty conduct laws applicable within their jurisdiction and adhere to them. Although many states have off-duty conduct laws, the reach of these laws have limitations. For example, some states do not allow employees to be discriminated against, refused employment, or terminated for their use of legal products such as tobacco while off the clock. In other states, it is legal to discriminate against smokers. It is important to note that off-duty conduct laws do not include protection for personal relationships. This is true even in states such as New York that offer the broadest off-duty conduct protections to employees. A company in Alabama terminated an employee for a very public arrest and subsequent 3-year suspended sentence for selling a small amount of marijuana to an undercover agent. An arbitrator reinstated the worker because the actions of the employee did not unreasonably harm the company's reputation or product, nor did his actions render him incapable of performing his duties. When the employer can establish a logical, if not obvious, connection between the behavior and the offender's job, it can often safely punish the person and make the punishment stick. This was true when the Elyria, Ohio Board of Education terminated a high school counselor who was convicted of a misdemeanor for her knowledge and consent of her husband's use of their home as a source of drug trafficking. According to Leap, the arbitrator said the board's action was reasonable because the counselor's conduct related to her work of advising students and parents on drug abuse. According to Walsh, terminations based on the protected class characteristics of employees, no less than any other adverse employment decisions, are discriminatory, disparate treatment. One of the best ways employers can mitigate the risk of claims of discriminatory termination is to treat all employees equally, applying policies to all employees in a consistent manner, and treating like situations in a like manner. While anti-discrimination laws protect workers from being mistreated based on protected class characteristics, plaintiffs must document discriminatory treatment in order to invoke these protections. This may be easier said than done because the subtlety of many contemporary forms of discrimination are not always easy to discern. However, in the case of unequal pay or wrongful termination, employees are often able to gather sufficient evidence based on information about coworkers or through interactions with the employer to identify and document unfair treatment. In order to limit the opportunity for wrongful termination suits, employers must be aware of the risks. When terminating an employee, it is important that the employer be clear about why the employee is being terminated. There are two main qualifiers that employers must be able to prove. These are substantive and procedural fairness. Procedural fairness is in relation to how the termination was carried out, and substantive fairness concerns a legitimate reason to terminate an employee. It is important for the employer to always have a clear documented reason for termination. Terminations can be considered high risk if it falls under one of the exceptions to the at-will doctrine. According to Van Begeert, justifiable causes include gross insubordination, performance below expectations, excessive absenteeism without excuse, and workplace violence, as well as restructuring of a company based on business necessity. Limiting involuntary terminations can be a proactive method of avoiding termination suits. Lowering incentive payouts, salary freezes, temporary layoffs, and reducing the work week are some options to find a balance and an acceptable alternative to terminating employment. Knowledge of employment laws and U.S. Supreme Court decisions will keep employers from making the same or similar termination mistakes. These decisions will assist an employer with further understanding of the circumstances in which termination should occur. And most importantly, employers should follow and adhere to any procedures in an employee handbook. For example, if there is a discipline action plan in place and this policy outlines the need for certain steps to be taken, these steps should be followed before termination. If steps are skipped, it will be important to address with the employee or in documentation why these steps have been skipped and what steps were followed instead. Following the appropriate steps will aid in showing an unbiased, fair termination if needed during a lawsuit. It is also important for the employer to avoid being accused of misconduct in the discipline and termination process by going through the appropriate channels and following the proper procedures. The decision to terminate an employee is rarely taken lightly by employers. There are many scenarios that should be taken into consideration before finalizing a termination. Employers should clearly document any reason for termination in order to avoid ambiguity that could lead to a wrongful termination suit. Special attention to laws and regulations currently in place, such as FMLA, ERISA, ADA, and Title VII, and stay current on court decisions regarding termination. Employers should also be aware of any language used in their employment documentation that may lead employees to believe they have guaranteed employment. Many employers use the at-will doctrine to protect themselves, but they must be aware of the limitations of employment at will. Employers may work to limit their risk for wrongful termination litigation through small steps. Some of these steps include offering options to the employee other than termination, properly outlining the employee's duties and expectations, effectively communicating the employee's misdoings and allowing them a corrective action plan, and following any steps outlined in company policy in regards to termination. It should be noted that documentation in a termination is vital for an employer, and any steps taken or not taken should be properly addressed so that in the case of a wrongful termination suit, the employer is covered.